Article 249 of the Revised Penal Code is homicide, and we are still in Title 8, that is your crimes against persons. Elements: number 1, a person was killed. Number 2, accused killed him without any justifying circumstance. Number 3, the accused had that intention to kill, which is presumed. And last is the killing was not attended by any of the qualifying circumstance of murder or by that of parricide or infanticide. So as far as element number 1 is concerned, that is self-explanatory. Go to number 2. For your number 2, just relate that to your Article 11 of the Revised Penal Code. That is your justifying circumstances. That is your self-defense, defense of strangers, or defense of relatives. How about number 3? Accused had the intention to kill, which is presumed. Take note that there are two kinds of presumption. First is your rebuttable or disputable presumption, and next is your conclusive presumption. If we are going to talk about homicide, take note that the general rule is pag may namatay, intention to kill is conclusively presumed. So pag may namatay, the charges against that accused should be homicide, because intention to kill is conclusively presumed. But how about if merong namatay but the person or the accused does not have the intention to kill? What crime are you going to charge that person? Answer is still homicide. Sabi nga ng Supreme Court, when death results, even if there is no intention to kill, the crime is still homicide and not merely physical injuries. Bakit ganyan ang batas? Because sabi ng Supreme Court, with respect to crimes of personal violence, the law looks at the material results following the unlawful acts and holds the aggressor responsible for all the consequences. Take note the law punishes the result and not the intent of the act. Element number 4, the killing must not be attended by any of the qualifying circumstance of murder or by that of parricide or infanticide. So what are the things that you need to remember? Number 1, again, the killing must not be attended by any of the qualifying circumstances of murder. So again huwag kalimutan si Article 248. Sabi ko nga, napakalungkot ng bar exams or ng midterms or your finals kung walang tanong tungkol sa Article 248. What else? The qualifying circumstance must be alleged in the information. So even if during the trial, the prosecution was able to prove na itong si accused ay talagang pinagplanuhan ang pagpatay kay X, talagang minatyagan niya for how many weeks itong si X, still that evident premeditation, if it is not alleged in your information, then you cannot consider that as your qualifying circumstance. Because what is the rule? That qualifying circumstance must be alleged in the information. Bakit? Because that would violate the constitutional rights of the accused. Number 3, if a qualifying circumstance is alleged but it was not proved, then what is the rule? You cannot consider that as your qualifying circumstance. Twin requirement, it must be alleged in the information and proven during trial beyond reasonable doubt. Let's go to bar exam question. Eddie has a son, Randy, so he brought his son Randy to a local faith healer known as Mother Himala. Randy was diagnosed by Mother Himala as being possessed by an evil spirit. Therefore, the father authorized the conduct of a treatment that would drive the spirit from the body of Randy. Unfortunately, the procedure conducted resulted in the death of Randy. The faith healer and the 3 others who were part of that healing ritual were charged with murder and they were convicted by the lower court. So question, so role-playing ha ang question. If you were the appellate court justice, would you sustain the conviction upon appeal? Answer is no. Bakit? Because there is no circumstance present that would qualify the killing to murder. Take note of Article 248. Meron ba sa ating problem na present under Article 248? Answer is wala. But what crime can you charge the faith healer and the 3 others? Answer is homicide. Bakit homicide? Because what did we say again? If there is death, kung may namatay, intention to kill is conclusively presumed. In the case of Mother Himala, wala naman siyang intention to kill Randy. In fact, ang gusto nga niya is to drive away the spirit from the body of Randy. But again, ano ang sinasabi ng Supreme Court? Pag may namatay, even if you do not have that intention to kill, the crime is still homicide and not merely physical injuries. Bakit? Because with respect to crimes of personal violence, ano ang tinitingnan ng batas? It looks at the material results. The law punishes the result and not the intent of the act. Going back to our general rule, when death results, pag may namatay, whether you have an intention to kill or you do not have that intention to kill, the crime is homicide. The crime is homicide as long as walang qualifying circumstance or justifying circumstance. But paano kung hindi naman namatay si biktima? What are the charges that can be filed against said person? Answer is, depende. Kung hindi namatay, then you can charge the person with either attempted or frustrated homicide or physical injuries. Kailan nagiging attempted or frustrated homicide? If there is intention to kill, then the crime is attempted or frustrated homicide. The offender must have that intention to kill the victim. Paano mo masasabi na merong intention to kill si accused? We will be talking about that in the next slide. But how about physical injuries? When can you charge a person with physical injuries? If there is no intention to kill. If there is no intention to kill on the part of the offender, then he is liable only for physical injuries, whether slight, less serious, or serious physical injuries, depende sa circumstances. What did we say in attempted or frustrated homicide? You have to prove the intention to kill on the part of the accused. But how can you prove intention to kill? Seldom ang cases wherein the accused would declare that he has that intention to kill a person. According to the Supreme Court, there are ways wherein you can prove intention to kill. Number 1 is through the means used by the malefactors. Number 2, the nature, the location, and the number of wounds sustained by the victim. Number 3, the conduct of the malefactors before, at the time of, or immediately after the killing. Number 4, the circumstances under which the crime was committed, the motive of the accused, and last is words uttered at the time of inflicting the injuries on the victim may also be considered. Bar exam question, Aki and Ben, while walking together, they met Kaloy. There was an altercation between Ben and Kaloy so that itong si Ben chased and stabbed Kaloy with a knife, hitting his right arm, thereby causing slight physical injury. But Ben already desisted from further assaulting Kaloy, but here comes Aki. Ano ang ginawa ni Aki? He lunged at Kaloy and felled him this time with a bolo, which mortally wounded Kaloy. Therefore, Kaloy died. Question, what is the criminal liability of Aki? Answer is, Aki is liable for homicide. But if you're going to read the reasoning of the UP Law Center, parang may hindi tama. Because what did we say? When death results, intention to kill is conclusively presumed. Pag may namatay, intention to kill is conclusively presumed. In fact, ang sabi pa nga ng Supreme Court, even if you do not have that intention to kill, if there is death, the crime is homicide and not merely physical injuries. Bakit? Because with respect to crimes of personal violence, the law punishes the result and not the intent of the act. How about the criminal liability of Ben? What is the criminal liability of Ben? Answer is, Ben is guilty only of slight physical injuries. Bakit hindi homicide? Because take note that si Ben is hindi naman siya nag-inflict ng mortal wound. But how about frustrated homicide or attempted homicide? Bakit slight physical injuries only? Because again, what did we say? If it is attempted or frustrated homicide, you must prove that there is an intention on the part of Ben to kill the victim or to kill Kaloy. But how do you prove intention to kill? Then, ano ang sabi ng Supreme Court? You have to look at the nature, the location, the number of wounds sustained by the victim or sustained by Kaloy. In our case, can we say that there is an intention to kill on the part of Ben? Answer is no, because while Ben stabbed Kaloy, but he stabbed Kaloy only in his right arm, and after that, he desisted already from further assaulting Kaloy. Therefore, according to your Article 4, kung ano lang yung result ng kanyang felonious act, and he is only liable for that direct, natural, and logical consequences of his felonious act. That is the reason why that he is only liable for slight physical injury. Another bar exam question, Lino and Okito are engaged in a street fight. Itong si Lino, he suddenly drew his balisong and lunged at Okito. But here comes Tommy. He has this effort to break up the fight between Lino and Okito. But before he can snatch the balisong away from Lino, Lino was already able to inflict a wound on Okito. But as Lino withdrew the weapon and attempted to stab Okito the second time around, itong si Tommy, he tried to grab the weapon again. But was he successful this time? Answer is yes. But what was the result? His left forearm was slashed and it hit Neryo, a passerby who was seriously injured. So question, what is the criminal liability of Lino with respect to Okito, Tommy, and Neryo? Take note ha that in our problem, walang naka-indicate na may namatay. So walang namatay. And if there is no death, what did we say? The crime is either attempted or frustrated homicide or physical injuries. Kailan nagiging physical injuries? If there is no intention to kill. Kailan nagiging attempted or frustrated homicide? If there is intention to kill the victim. And how do you prove intention to kill? There are 6 ways according to the Supreme Court. But going back to our problem, ano ang liability ni Lino with respect to Okito? As far as Okito is concerned, Lino is liable for frustrated homicide. Bakit frustrated homicide? Because there is intention to kill on the part of Lino. Why did you say that there is an intention to kill? Ano ang sabi ng problem? Binalikan pa nga ni Lino si Okito na stab for the second time around. That's why intention to kill can be inferred. But how about Tommy? How about Tommy? Since kay Tommy, he has no intention to kill, Tommy is only there because he has this effort to break up the fight between Lino and Okito. Therefore, Lino is liable only for physical injuries. How about Nerio? Nerio, he is a passerby. Well, he was seriously injured, but because Lino has no intention to kill him, then Lino is only liable for serious physical injuries according to your Article 4. Before we read the other bar questions, let's go to this one first. Pag kayo ay nakakita ng bar exam question or if you are confronted with a question and nakita nyo that prior to the killing, there was a heated argument, there were insults, or pinatay niya dahil sa kanyang galit, then wag agad mag-conclude ha. Kung nakita nyo na pinatay siya ng walang laban-laban, wag agad mag-conclude na that it is treachery. Bakit? Because take note that passion is incompatible with treachery. What is passion? Passion is your mitigating circumstance. And in passion, the offender or the accused loses his reason and self-control. But what is treachery? Ano ang sinasabi natin sa treachery? There must be two requirements that must be present. And requirement number 2 is very important. The mode of attack must be consciously adapted by the offender or by the accused. If sinasabi natin that in passion, the offender or the accused loses his reason and self-control, therefore, it is incompatible with treachery. Bakit naging incompatible? Because in treachery, dapat the offender or the accused deliberately employ a particular means, method, or form of attack in the execution of a crime. That is the reason why passion is incompatible with treachery. Next. There is no treachery where the assault upon the deceased was preceded by a heated exchange of words between the accused and the deceased. It cannot be said that the deceased was caught completely by surprise when the accused took up arms against him. Dapat ine-expect mo na yon. Kung kayo ay nag-aaway, nagbabangayan kayong dalawa dyan, expect mo na yung kalaban mo ay babalikan ka. Let's go now to bar exam questions. So here is A. A is a security guard. He was insulted by the manager of the bank where he is working. Enraged, A shot the bank manager who died on the spot. As A was about to leave the bank premises, he noticed the vault open. So he entered and forced open a locked container and he got the jewelry therein. Question, if you were the fiscal, for what crime or crimes would you prosecute A? Answer is homicide and robbery. But let's not go to robbery. Other topic pa yan, sa later pa yan ng mga videos. But why homicide? Bakit homicide? Bakit hindi murder? Nung pinatay naman ni security guard si bank manager, si bank manager is walang kalaban-laban. But take note that prior to the killing, there was an insult. The bank manager insulted the security guard. So therefore, there is now passion. But passion negates the presence of treachery. Ano ang sinabi ulit natin? Passion is incompatible with treachery. Well, passion is a mitigating circumstance, and in passion, the offender or the security guard in our problem loses his reason and self-control, but still it is incompatible with treachery. Bakit? Sa treachery, dapat si security guard must deliberately employ a particular means, method, or form of attack in the execution of a crime. Therefore, you cannot consider treachery as your qualifying circumstance. So, kung walang qualifying circumstance, and then kung wala ding justifying circumstance, but there is death, the crime is homicide. Another bar exam question, X killed Y in a fit of anger. While in the act of disposing or concealing the body, he found some money in the pocket of Y and he took it. Question: what crime has X committed? Answer is, he committed the crimes of homicide and theft. Bakit homicide? Because you go back to the facts of the problem. There is no indication there that there are qualifying circumstances. Walang circumstance that would qualify the crime into murder. And also, there is no justifying circumstance. Therefore, pag may namatay, the crime is homicide. Another bar exam question. Emilio and Andres were walking home from the farm when they met Asyong, whom Emilio suspected as the one who stole his fighting cock 2 days before. So itong si Emilio, he confronted Asyong, and after a heated discussion, a bolo fight between Emilio and Asyong ensued. Asyong sustained fatal wounds and then he died. So what is the criminal liability of Emilio as far as the death of Asyong is concerned? Answer is, Emilio is liable for homicide. Bakit homicide? Because the killing is not attended by any qualifying circumstance of murder. It was a killing at the spur of the moment, in the course of a bolo fight, and as an aftermath of a heated discussion. Ano nga ulit ang sinabi natin? If there is a heated exchange of words between the accused and the deceased prior to the killing, then you rule out treachery. Bakit you have to rule out treachery? Because it cannot be said that the deceased or the victim was caught completely by surprise when the accused attacked him. Expect mo na yan na kung kayo ay nagbabangayan, nag-aaway kayo, talagang magre-retaliate itong kalaban mo. Take note that the crime of homicide may be committed by negligence. So if there is negligence and may namatay, then what you can file is reckless imprudence resulting in homicide. But what if hindi namatay, merong negligence, but there is intention to kill? What can you file rather? A reckless imprudence resulting in frustrated or attempted homicide? Answer is no. Bakit? Because if you go to your Article 365, one of the elements of reckless imprudence is there must be no intention to commit the wrong done. And when we talk about frustrated or attempted homicide, ano ang sabi natin? There must be intention to kill the victim. Therefore, intention to kill in attempted or frustrated homicide and no intention to kill in reckless imprudence, they are therefore incompatible. This is the reason why there is no such thing as reckless imprudence resulting in frustrated or attempted homicide. The element of intention to kill in attempted or frustrated homicide is incompatible with negligence or imprudence. But how about if hindi naman namatay si victim and there is negligence? What can you file? You can file reckless imprudence resulting in physical injuries. When there is where the victim does not die, the crime is either reckless imprudence resulting in physical injuries, either serious, less serious, or slight. So again to reiterate, there is such a thing as reckless imprudence resulting in homicide. There is also such a thing as reckless imprudence resulting in physical injuries kung hindi namatay. But there is no such a thing as reckless imprudence resulting in frustrated or attempted homicide. To illustrate, let's read this bar exam question. In the course of funeral procession, there was this young mourner who momentarily stooped down to tie her shoelaces. The driver of the hearse, who was driving at 5 miles an hour, was at the time looking at the stores by the roadside and did not see this young lady. The driver continued to drive on and ran over the girl. When the people around shouted and gestured, the driver backed up and ran over the girl a second time, killing that girl. Question: if you were the parent of the girl victim, what crime would you charge if you think a crime had been committed, and against whom? Answer is, that driver will be charged with homicide through reckless imprudence. Again, what did we say? Pag may namatay, even if you have that intention to kill or there is no intention to kill, that is always homicide. But because of our problem, according to the facts, wala naman talagang intention si driver to kill the young lady. In fact, he was driving at 5 miles an hour. That is equivalent to 1 mile for every 12 minutes. But because of Article 4, according to your Article 4, you will always be liable for the direct, natural, and logical consequences of your actions. But since the felony was committed by means of or by lack of foresight or lack of skill, therefore, you will be only liable for reckless imprudence resulting in homicide. Take note of this one, ha? If you will be confronted with a question and makikita mo dun sa question that there are two or more offenders or there are two or more accused, then everybody inflicted injuries on the victim, but it cannot be determined who is the person responsible for the death, then the rule is everybody is liable for the death if there is conspiracy. Take note, ha, everybody is liable for the death if there is conspiracy. How about if there is no conspiracy? If there is no conspiracy, but everybody inflicted mortal wounds, then again, everybody is liable for the death. But how about if there is no conspiracy and you cannot determine who among the accused or who among the offenders inflicted the mortal wounds, then the rule is everybody is still liable for the death. Another thing to remember is, as in all other killings, the accused may be convicted of homicide even if the body of the victim has not been found. What is important is corpus delicti has been proven. So what is corpus delicti? It means the fact of the crime. It means that a crime was actually perpetrated. It does not refer to the body of the murdered person nor the object robber or stolen from the owner. Ang best example nga dyan is kung meron kang hinulog sa barko, do you need to recover the body of that person in order for you to be convicted of homicide or murder? Answer is no. What is important is you are able to prove or you are able to present satisfactory evidence of the fact of death and the identity of the victim. Let's go now to Article 250, the penalty for frustrated parricide, murder, or homicide. But before we discuss further Article 250, let's go first to Article 50. Bakit sa Article 50, ano ang nakasulat dyan? If the crime is a frustrated felony, then the penalty is the next lower in degree or 1 degree lower than that prescribed by law for the consummated felony. How about if it is an attempted felony? Then Article 51 has the answer. The penalty should be lowered by 2 degrees or 2 degrees lower than that prescribed by law for the consummated felony. But if you go to your Article 250, ano ang nakasulat dyan? The court is allowed. The word used is may. So the court may impose a penalty that is 2 degrees lower for frustrated parricide, murder, or homicide. So very specific, ha? Parricide, murder, or homicide. And if it is an attempted parricide, murder, or homicide, then the court is allowed to impose a penalty that is 3 degrees lower. But take note that if there is an attempt or conspiracy against the life of the president or that any member of his family or against the life of any member of his cabinet or the member of the family of that cabinet member, the penalty is death.